Hi, I'm Christopher Burgon. I own and run Christopher Burgon Solicitors. We are a specialist litigation and commercial law firm based in London. This is the third video on freezing orders. We've two previous videos, go and have a look at them. One is about what you need to convince the court of in order to get an order. This is a very specific topic and this is known in the trade as full and frank disclosure. That basically means that if you go to the court for a freezing order, you have to tell them everything that you know. The Brink's mat robbery from the 1980s, it's very exciting, massive theft of gold from the Brink's mat warehouse, used to develop pretty much Canary Wharf, if you believe what the TV dramas tell you. We are going to cite a Brink's mat case, Brink's mat versus Elcombe, 1988, and we're going to cite it for the really exciting bit about the Brink's mat robbery, which was the court's decision on full and frank disclosure in freezing orders. Why did Brink's mat want a freezing order? Well, of course, the money from the gold had trickled down to a couple of companies. One of those companies had bought a quayside property in Canary Wharf, and they had transferred their interest in that land on Canary Wharf out to a Panamanian company. So the money going into that British company was very likely going to end up in Panama. That's a real risk of dissipation. So Brink's mat went to the court looking for a freezing order, but they got caught up on full and frank disclosure, and it turned out the court found that they hadn't been full, they hadn't been completely honest, completely frank in their disclosure. The court set out some very interesting principles about full and frank disclosure in this case. It said that you must tell the court about everything that is material to the case that you're bringing. So that's everything that's material, what's for you, what's against you. Not only that, but you should make inquiries to ensure that you have all reasonable material facts. And your inquiries must also satisfy the court. They must be seen to be reasonable and thorough. So you've got to make inquiries so that you can tell the court that you know most of the material facts, or you could be relatively sure that you know most of the material facts, and then you have to give all that material information to the court when you're seeking your freezing order. Now, if you don't do that, it's entirely possible that you will not get your freezing order. You may satisfy all the other tests, which we mentioned in the second video, real risk of dissipation, jurisdiction, good arguable case, but if you haven't complied with the full and frank disclosure obligation, you will not get your freezing order. But here's what happened in the Brink's mat case. The Brink's mat people were found not to have complied with their disclosure, full and frank disclosure obligations. But the court said that even if they had, it wouldn't have made a difference to their decision on whether or not to grant a freezing order. In this case, to have not granted a freezing order would also have so obviously prejudiced Brink's mat that the first decision to grant a freezing order, even though disclosure hadn't been properly complied with, stood, and the freezing order continued. So there you go. Brink's mat, the most exciting thing about the Brink's mat robbery is full and frank disclosure. In that case, they didn't comply with full and frank disclosure. That can lead to the freezing order being denied or discontinued, but in the Brink's mat case, because it was such an obvious case, it didn't. I hope you found that was helpful. If you want to bring a freezing order action, or you've been threatened with a freezing order, please get in touch. We'd love to hear from you. Please go to the website, press the book a meeting button. That gets you a 30-minute initial conversation with us, absolutely free. Alternatively, drop us an email or give us a call and we'll call you back. Thanks very much.